Good afternoon, everyone. It seems to be 12:01, so I think we'll go ahead and get started. Just working out a couple of little technical glitches here at the very end. And let's see, you should now be seeing the slides with nothing else on top of them. Bob, can you give me a thumbs up if that's accurate? Thank you. All right, awesome. So good afternoon, everyone. My name is Joy, and I am an attorney with the team at Western Center on Law and Poverty. And with me today is Bob Newman, our senior counsel, and all-around good guy. So we are here to present today on litigating in a hostile environment. So a couple of things before we get started. A couple of tips for the Zoom, for operating the Zoom environment, although most of us already have been in, just in case. There are closed captions on this slide, or sorry, on this presentation. You can turn them on at the bottom by clicking on the Show Captions button. If you have questions, please submit them at any time using the Q&A panel, not the chat. We will answer as many questions as possible as we can during the discussion. Use the chat feature for comments, technical issues, or to share resources with participants if you have those. If you have accessibility needs or encounter technical barriers, please let us know through the chat as well. The session is being recorded, and any shared materials will be provided after the webinar. Let me just check and confirm that we are, in fact, being recorded. Yes, we are. All right, excellent. Okay. So about Western Center. Western Center on Law and Poverty fights in the courts, cities, counties, and in the capital to secure housing, healthcare, and public benefits for all Californians. We advocate through the lens of economic and racial justice for a strong safety net for those in need. So the first thing we're going to do is take a poll so we can get everybody's MCLE as appropriate. Let's see, and here it is. Please respond to the poll as appropriate. Let's see, we'll need your organization, your bar number if applicable, and your email address. So we'll just give you a minute or so to fill those out, please. Okay, we're getting there. About half of you have finished. Stand by another minute or so. Got another 30 seconds for the poll for those of you who haven't gotten it done yet. For the attorneys in the room, you must have this poll filled out or we cannot get you MCLE. Okay, so while the rest of you are still wrapping that up, we will go ahead and proceed. So here's our goals for today. You will learn what we mean by a hostile environment and how to get started in litigation in such an environment. We'll talk to you about the questions that you need to ask when you're deciding whether to bring a lawsuit, show you some lessons from a few recent impact cases, and finally offer some practical advice for doing the work. So first up, what do we mean by hostile litigation environment? So there's a couple of elements to this when we talk about this. The first one, of course, is the political environment. So there's a lot of administrative uncertainty because a lot of issues that are affecting poverty and racial justice are, of course, politically contested. This creates rapid policy changes between administrations, conflicting state and federal policies, as we've seen in the state of California quite a bit. It makes folks file litigation immediately after new laws or regulations are adopted with pressure to obtain emergency relief. And that means that advocates often find themselves litigating in an environment where policies are changing before cases conclude. And this constant change leaves us with no way to predict what's coming next. And then, of course, administration-driven restrictions on government programs and civil rights, which we are seeing in this administration with the plethora of executive orders trying to make law and, of course, subsequent litigation against those executive orders. The next element is the courts. I don't know where that title went. Anyway, we're going to talk a little bit more about this later on, but know that what we're talking about when we talk about the courts is a more skeptical judiciary, the unbalanced nature of the Supreme Court, 6-3, conservatives to liberals, and their apparent willingness both at the Supreme Court and at the federal court levels to overturn precedent. And then the media environment. So the public perception, litigation is happening alongside competing stories about poverty, race, gender politics, immigration, access to healthcare. It's everything everywhere all at once. And it makes it very difficult to focus anybody's attention on your issue. So how do you get started? The big first step, find the issue that is ripe for intervention. So you're looking beyond the individual harm, asking yourself, is this a recurring pattern? Is this something that's happening in multiple places to multiple people? Or is this just a singular event that has occurred that's harming one particular individual or small group of people? Because what you want, of course, is something that is recurring, something that can be repeated, something that's not going to be made moot by that one person's issue being resolved. Ask yourself, who is the most affected? Are we talking about entire racial groups? Are we talking about entire geographical areas? Are we talking about particular recipients of a particular benefit? So we need to identify in your issue who exactly it is that's most affected and how they are affected. And then ask yourself, is there a policy choice that's driving the harm? Because that's the kind of case that's, number one, most difficult to litigate, because you do have that the heaviness, the weight of the government policy that is causing this, but it also makes it a good issue for intervention because you can focus on that policy. And by striking down that policy, you can often mitigate the harm. So examples of this are things such as housing instability, where you've got issues around homelessness prevention, around affordable housing. Access to healthcare, of course, is a big one right now with HR 1 changes to Medi-Cal. Public benefits barriers, again, an HR 1 problem. Things such as work requirements and increased reporting requirements, things that are don't seem to have much purpose and are creating this barrier to receiving benefits. And another example is debt and economic exclusion. So things like medical debt, things like high fines and fees. These are examples that tend to be ripe for intervention when they are first created. The second thing that you need to do is think about coordinating advocacy. So effective change often requires this multi-pronged coordinated approach. And that involves community organizing and community lawyering principles, policy research, legislative advocacy, a media strategy, of course, litigation, and then enforcement monitoring. All of these things reinforce each other and lead to that lasting change, the systems change that you're looking at. So this is not just about filing cases in court. This is about thinking about this multi-pronged approach, about coming at it from every possible direction. All right, number 2, and the bulk of our presentation today, what questions should you ask when deciding whether to bring a lawsuit? And with that, I will turn it over to Bob.
And I'll start by saying that the 5 questions don't necessarily have to be asked in that order, although I would probably start with who. And then after that, they're interrelated questions. And then here I'm just focusing on lawsuits. So Joy, can we go to the next slide? Okay. So the threshold question, who's the bad actor? Who's committing the wrong here? And the answer is, if it is the federal government or federal officials, then you're basically going to be stuck going to federal court. And you're also going to be stuck arguing federal law. So that's the starting point in sort of a determination. If, on the other hand, you're looking at the bad actors being state officials or state government or local officials of local government, or even private officials, be it nonprofits or corporations, whatever, then you may have a choice between state and federal court and also state and federal laws to sue over. The other question is, who's getting impacted by the wrong flag? So I've sort of talked about the defendants. Let's talk just briefly about the potential plaintiff. Who comes through the door, or sometimes we go out looking for people who can represent and bring an issue. And in that situation, probably the biggest question to ask is the harm irreparable. Going back to basic law school, what is irreparable harm? Irreparable harm is some injury to somebody that cannot be fully compensated by monetary damages. To make our lives easier, there's a whole body of case law that says, for example, the loss of SNAP benefits is irreparable harm. The loss of Medi-Cal is irreparable harm. The loss of CalWORKs benefits is irreparable harm. So there's a body of law that says that all these involve irreparable harm, because even if you pay somebody, a couple $100 later, it doesn't compensate them from going hungry or missing out on medically necessary care. I'm going to come back a little bit more to talk about irreparable harm a little later on. If we can go to the next slide. Okay, this is covers a whole variety of issues, when you start thinking about it. Are your claims under federal law, state law, or both? The differences on the claims can make a big difference as to both what is the substantive rights you're suing over and where you can sue. I've given a couple of examples. If you brought a claim under the Americans with Disabilities Act, then it's the body of law is going to be federal law, but you can sue in both federal or state court. On the other hand, the Fair Employment and Housing Act is a state law. That's one where there's, again, the body of law is in state court, but you can, and it's state law. If it's the SNAP Act, that's federal law. Now, the SNAP Act itself does not give rise to lawsuits. So let me go in and just give 2 more examples. If you want to go and sue over violations of the SNAP Act and you want to bring a claim under federal law, then it's 42 U.S. Code Section 1983. That's the Civil Rights Act. The argument in that case is where the deprivation is, it's a deprivation of your rights under the SNAP Act. So the claim is one involving federal law, where 1983 borrows them from the SNAP Act in terms of what you allege is the wrongdoing. 42 U.S. Code 1983 claim can be brought in either state or federal court. I'll give just one more example. For those who are not familiar, there's Code of Civil Procedure Section 1085. That's a writ of ordinary mandate. That's one that can be brought in state court, has to be brought in state court. And here, too, it can borrow from violations of federal law, such as violations of the SNAP Act. Okay, What impact does the identity of the bad actor have on the choice of law? As I said a little while ago, if you're talking about federal officials, you're pretty much stuck going to federal court. And you notice I use the term stuck. Um, if it's state or local government, you have a choice depending on what laws are being violated, whether it can be brought in state court or it has to be brought in federal court. Same can be said about private agencies. Again, you may have a choice. Um, in getting prepared to bring these types of lawsuits, many of them are being brought in federal court involving challenges to federal law. The thing you really have to bone up on is the Administrative Procedures Act. And here I'm talking about the Federal Administrative Procedures Act. We could go into a long training. It would go on well for over an hour about the APA and what's involved there. But if you're thinking of doing a case and it involves federal official, you pretty much have to know the APA. Okay. The last thing to think about, in terms of if you have a choice sort of between federal state court, what happens if you win, if you lose? The general rule of thumb is winning in a federal district court has more clout or more meaning than winning in a state superior court. The best evidence of that is any ruling in a state trial court can't be cited in the state court system at all. There's no precedential value to it, whereas a federal district court decision can be cited. If I then go to the next slide. Okay, when is the thing I'm going to talk about, because I've taken my lumps in a number of cases that the Western Center has been brought about the timing. And here's really is the struggle. You have to figure out when to file it. And I will have to say in general, you should file before the wrongful act occurs. If you bring suit after the occurrence of the wrongful act, there's one possibility that your lawsuit will be moot. It makes it extremely difficult to get any form of injunctive relief. And it also impacts whether you even have much of a lawsuit. We've been involved in a number of cases where we weren't the first ones to file suit. First ones to file suit were the Attorney General's office, and they filed before the wrongful act occurred. We filed afterwards. And the upshot is that their lawsuit was basically the dominant lawsuit. And it was sort of hard for us to get heard thereafter. When can you file the lawsuit? You should try and file it in such a time that allows the court adequate time to rule. In most of these cases, we're talking injunctive relief. My general rule of thumb, I always tell people, is for a temporary restraining order, and this is both either in state or federal court, what you're basically telling the judge is you need to maintain the status quo. If you do not do something by tomorrow or the next couple days, something irreparable harm involving irreparable harm will occur, and it's too late. And so that's the operating principle. Now, if you bring the suit and it can wait a couple weeks, then you might not need a temporary restraining order. And what you may be doing is only going to the court for a preliminary injunction. But the timing question is critical in this area, and you should think long and hard about whether you're able to bring the suit in a timely manner. If we can go then to the next slide. If you haven't gotten the sense of it already, here's the general rule of thumb. State courts at this point in time are better than the federal courts. Joy touched upon it before. You can start at the U.S. Supreme Court. The 6 conservative justices there, that's nothing. Our California Supreme Court is infinitely better than that. If you go down another level, at least out here, the Ninth Circuit Court at this point once was great. It's now very much a mixed bag. The California courts of appeal, depending which one, are a mixed bag as well. There's some better than others, but as a general rule, they're they are considerably better than the federal courts. And then finally, at the trial court level, it depends, but there are a lot of conservative judges now sitting in the federal district courts whereas we've now had many years of Democratic governors appointing Democratic judges. And even before that, they were appointing better judges than you see in the federal system. So if you have a choice, and it is something that can be brought in state court and involves state law, you should probably give serious consideration to it. But what if you don't? As I indicated before, it involves challenges to what federal officials have done. You're pretty much going to be stuck in federal court. And in that case, you may want to think about which of the federal courts. It is no accident that a large number of lawsuits challenging the Trump administration that have been brought in California have been brought in the Northern District of California, which is located in either San Francisco or Alameda County. If you go beyond that, it is no accident that a large number of the cases challenging the Trump administration have been brought in either the District Court of Massachusetts or Rhode Island. They have, on balance, very good district court judges and better Court of Appeal justices. So the next slide. So why do I basically say state court over federal court? And I'm going to work my way from the last third bullet backwards. Well, it's the standards on standing is one of the big things. As a refresher for people, in federal court, you're confronted with what is called Article 3 standing. The three requirements, just real briefly, are injury in fact, causation, and redressability. One of the things that conservatives have been doing at the Supreme Court level over the last 20 years is making standing harder and harder for people to bring lawsuits. Another consideration is if you're a program that can bring a class action, the standards on class actions are tougher and more restrictive in federal court than, say, state court. Agency authority, that's actually sort of more complicated. At this point, the U.S. Supreme Court is giving less deference to the agency, but they're also giving sort of more deference to themselves. Then as to statutory interpretation, I had to think about it a little bit. I don't think there's, in theory, that much difference between state courts and federal courts as to the general rules. But what you certainly see coming out of the Supreme Court is very restrictive notions of what a statute can do, and particularly in our areas that we care about. Moving our way up, on narrowing access to remedies, all I can say is you betcha. I mean, part of what has gone on over the last 20 years and is now in full swing is to limit as much as possible the relief that one can get in federal court on the cases that we care about. So going to the first one is, if you have a choice in judge and jurisdiction, think about it. Having said to you that you should prefer state court, if you have a chance of getting a good federal district judge, and it's an issue that the federal law may be reasonably good on, and you think you have a decent chance on at the circuit level, I wouldn't take a knee-jerk response of necessarily not bringing the case, but I'd give it thought. So if I can go to the next slide. Okay, so this is returning sort of to who, in terms of looking at your plaintiffs. Again, this could be a full training, so I'll just cover it real briefly. On a plaintiff, what do we mean by clear injury? I think in this context, more than else, it's probably irreparable harm we're talking about. Now, as I said before, the loss of food stamps or Medi-Cal involves irreparable harm. Courts have said that. But that being said, there's differences in irreparable harm. If somebody's going to lose food stamps, if you talk to the client, will they go hungry tomorrow? Or for whatever reason, they can get by for a week or two, or can they get by for a couple of weeks? And then you have to evaluate that in terms of your own timing of the case, because if they're going to go hungry tomorrow, are you in a position to file tomorrow? If, on the other hand, it may be they can go on for a couple of days or a couple of weeks, that may make it actually easier to bring the case. Obviously, credible story is not the term I would probably use. Is their account of the facts accurate? I wouldn't call it a story. It's description of the events correct. And when you vet them, do they stand that? You also have to vet them on their willingness to participate and explain to them what's involved in a lawsuit and all that's entailed in that and understand what they're taking on. And in almost all the cases we do, it's not just for their own personal benefit, it's for some broader group. You have to connect it to the broader systemic issues. Going into risks, I'll just say on scrutiny, if you have a potential client and you think it's going to be a big case, you should vet them and vet them carefully. And the only two words I can give you in this day and age is Graham Plattner. He was not vetted. Our clients, depending on how serious the case is, may not be subject to the same level of scrutiny as Mr. Plattner, but they may be subject to serious scrutiny. So as an aside, I would suggest if they have social media, you may want to review all their social media to see whether they're vulnerable. The related question then on litigation fatigue is you have to talk to folks about give them a reasonable sense of the time frame it's involved and whether they have the stamina and the willingness to stand up the whole time. And the same is true to what may be personal attacks. They may be subject to a deposition, and they may be hit in the media. And so in reviewing with them, are they prepared to take it on? So the next one. So given all that, the last question is, I think, sort of, if you've gone through all this, should you bring a case? Does it make sense? What you've heard from me is that in some of these cases, with the benefit of hindsight, I'm not sure all the lawsuits we brought didn't make sense. Particularly if you think the issue is going to be taken up by the Attorney General's office or by some of the other agencies that are now out there bringing these types of cases. You might, in that situation, though, think about intervention. You might think about doing amicus, but I don't think it should be, we necessarily have to bring the case. What you have to think about is, are we fulfilling a purpose? Is there something that we really can make a difference on, and it makes sense to bring our own case? So that's it. Back to you, Joe.
So the last question to consider is, what do you do if you go through all of that and then decide that maybe litigation is not the right answer? So what you should do right from the very beginning, we recommend, is build those multiple pathways that we talked about in a previous slide. Consider community organizing, consider legislative advocacy, consider other ways to get what you need done. Because what this does is it avoids that possibility of a single point of failure. So even if you do decide to litigate, we do recommend that you take a look at those other pathways as well. Because if you lose in your litigation, or if you decide you can't litigate, then there are other ways to get it done. And you want to focus on those right from the beginning from your original strategies. Some of those other options, as we mentioned, include legislative strategies, administrative strategies, that is, dealing advocacy directly with the organizations, departments, agencies involved. Public education strategies. Always consider the media as an option. The media can be a friend, the media can be an enemy, but if you work it and consider it from the beginning, you can bring in the media and you can have that element of public education. Because if you and your organization alone can't rise up to get this done, an effective media strategy can help the public rise up. And of course, our politicians love or hate when the public gets riled up about something. So that is always an alternate option. Okay, time for our case studies. So we're going to start out first with a currently active federal case, Clinic v. Rubio. Rubio as representative of the State Department. Clinic, not a health clinic, stands for Catholic Legal Immigration Network, Inc. And they are one of two organizations that were engaged in this case. So the problem was the State Department indefinitely suspended the issuing of immigrant visas to applicants from 75 countries. The vast majority of these countries were in Africa, Asia, Latin America, the Middle East, and Eastern Europe, countries whose populations are majority non-white or composed of white ethnic minorities. Simultaneously, 2 diplomatic cables were sent to consular offices that significantly changed processes followed by consular officers in evaluating visa applications. So the ban was allegedly implemented due to the Trump administration's concerns about the vetting process and about immigrants becoming a public charge. But even applicants who've been fully investigated and already approved for visas, who had been determined by immigration officials not to be a public charge and who were just waiting for their visas to be printed, were ordered to be denied under the ban. The administration claimed this was necessary to prevent immigration of those who might extract wealth or take welfare and public benefits from the United States. But this claim is demonstrably false. Most applicants for immigrant visas are not eligible for cash welfare, and they remain ineligible for many years. Some immigrants may ultimately be eligible for certain emergency services and public programs that Congress has decided they should be eligible for, but studies have shown that using or receiving those benefits does not determine whether someone is likely to become a public charge. Far from extracting wealth, immigrants pay state, local, and federal taxes that help fund the services used by all U.S. residents, including citizens, and contribute to the overall economic growth in the United States. So just a very quick public charge, in case some are not versed in immigration law, has to do with the idea of whether somebody is going to become a burden on the U.S. economy, a burden on society when they arrive in the country. So the result of this visa ban has been a blanket deprivation of case-by-case immigration visa issuance process that the law requires, based only on the nationality of the applicant. And this, of course, is blatant discrimination against both immigrants and their U.S. citizens' families based on race, ethnicity, or national origin, all of which are prohibited by the Bill of Rights. And then the second piece of this was the consular cables. One was instructing as to the visa ban, and the other one was an unlawful attempt to authorize consideration of a broad array of public benefits outside the longstanding definition of public charge. It rewrote how affidavits of support are evaluated and injected new discriminatory considerations into the statutory 5-factor analysis that Congress prescribed. In doing so, the State Department replaced the Immigration and Nationalization Act's narrow, individualized public charge inquiry with a far broader and more exclusionary regime that Congress never authorized. So this was just bad, bad, bad all the way around. So our strategy, we identified 12 individuals and 2 organizations that were impacted by the ban and the cable who were willing to stand up. It was really important to find organizations, again, because of that mootness factor. Because if you only have individuals involved in your impact litigation, and those individual issues are resolved, then your case can be mooted. Or in the case of a politically charged case in a hostile environment, your individuals may get too scared and they may drop out, and then you're left with no one. And so we brought in the Catholic Legal Immigration Network and African Families Together. We filed a 107-page complaint. It didn't start out to be that long, but that's how it ended up, alleging 7 categories of violations of the Administrative Procedures Act, plus Fifth Amendment equal protection violations, and exceeding the authority granted under the Constitution, something known as ultra vires. We sought declaratory and injunctive relief, vacator of the cables and the ban, and a set aside, and an order to resume regular immigration processing. So the challenge to this is, of course, immigration as a hot button issue. That environment right now is particularly hostile because immigration, both legal and undocumented illegal immigration, are just stirring everybody up. It is high in public consciousness right now. Another challenge is the probability, not just possibility, of retaliation against our organizations and our individual plaintiffs. This issue was way too big for one nonprofit law firm, considering everything else going on. And important to note, should have been on the previous slide, that Western Center was not the lead organization on this. In fact, we were not lead by far. The firms involved in this are the National Immigration Law Center, Democracy Forward, the Legal Aid Society, Center for Constitutional Rights, and a private immigration firm from Washington, Colombo, and Heard. So all together, we got engaged in this thing. We came together to handle this huge issue. And then the last challenge, of course, was the propensity of the Supreme Court to take appeals and rule in favor of the administration. So even if we get what we want at the district court level, challenge is what's going to happen at the next level. So the outcome to date, so far, this case is still very much active. We saw a partial summary judgment on March the 10th, declaring that the blanket visa ban, both the ban itself and the connected cables, were contrary to law, in excess of the defendant's statutory authority, and procedurally invalid, and asked the court to hold unlawful and set aside the ban. Just 2 weeks later, the defendant sought a competing summary judgment, alleging that our APA claims failed as a matter of law and that our plaintiffs lacked standing. Unfortunately, we are still waiting on these decisions in either of these, which were due in mid-May. So we're just standing by at this point. The lesson we learned out of this is that you can play a role, your firm can play a role, even if you are remote to the case and small. So all of this is taking place in the Southern District of New York Federal Court. All the other organizations involved are in Washington, D.C. and New York. But we were able to come alongside for drafting help, for discovery, for amici coordination, and who knows what else in the future. So we are able to provide help with this, to play a significant role in this very large case, even though we are a small nonprofit ourselves. Another lesson, these things take longer than you want, because of course this ban went into effect beginning of January, and we're now almost into August, and countless families have been stuck or denied or prevented from moving forward with their lives because of this ban and the hold that's on everything. Connected to that, just because we're in a hurry doesn't mean the court is, unfortunately. And the last lesson on this one is that a media campaign can be a blessing and a curse. The blessing part of it is, of course, that it's out there, and everybody knows that we are fighting this thing, that it's not a done deal as far as we in the courts are concerned, and that there may be an out. The other flip side of that is that everybody knows we're doing this, and it is out there. And we are still 7 months later, getting emails from individuals begging for us to help them in their particular case. And so initially it was sort of a good thing, because we were finding other folks that might be willing to be involved in the case. But at this point, we get these emails and we just have to answer and say, stand by, because there's nothing that we can do for your individual case at this point. Just stand by. So that is Clinic v. Rubio. And over to Bob for Perone v. Rollins. You're on mute, Bob. Still muted.
Yep,
There you are.
My apologies. As the slide says, the federal government refused to fund SNAP benefits during a congressional budget impasse. For some of this, it's been a repeat of what has gone on over the last maybe 10 years. If people may recall, there have been a series of these budget impasses, and each time SNAP recipients were faced with the prospect of losing their benefits. And each time, up until the very last go round, the Congress resolved it before the cuts went into effect. So this was the first time where the cuts went into effect and people actually lost out on benefits. We were involved in a number of prior cases before Perone, and each time we got mooted out. One of the cases actually, the Biden administration was still in office, got them to agree to an accounting mechanism that allow for sort of an extra month of benefits. But so this was yet another threat to people's SNAP benefits during a congressional budget impasse. You can go to the next slide. Okay, so what we came up with as a strategy, and this was the Western Center working with the Impact Fund, was to file a nationwide class action in federal court alleging that the suspension of SNAP benefits violated various provisions of federal law. What I'd like to do is read for a half a minute of what is the first paragraph and a half from the complaint. I think it's incredible writing for a complaint. I can also say this because I didn't write it, so I'm taking no credit for this, but this will show you how powerful was the writing and also what the problem was. Food or rent, food or medicine, food or transportation, food for me or food for my children. These are the real life choices that 1 in 8 people in the United States, including plaintiffs Kelly Ray Peroni, Anika Okochi, Urban Browning, and Cynthia De La Mora, are now forced to make daily because defendants are failing to fund their SNAP benefits. Plaintiffs bring this lawsuit on behalf of themselves and the proposed nationwide class of approximately 42 million recipients of federal food benefits who are harmed by defendants' failure to fund supplemental nutrition assistance program benefits absent a congressional appropriation. I think that's, as an aside, I just thought that was great writing. For a complaint, if you're doing a motion for preliminary injunction, you should keep it in mind. And as again, I want to repeat, I can say this because I didn't write it. So if we can go to the next slide. The big challenge on this lawsuit, and what was a challenge on all the other ones, was when to file. Because if you filed too early in the process, say a couple of weeks or months before the impasse, a court looks at you as though the dispute isn't ripe, and it may also be moot. If on you file too late, which is what ended up happening here, the suspension of benefits might already take effect. So it's sort of like the Goldilocks. You had to come up with the exact right time. Another struggle in our case and the other ones that were brought is that one claim, and it was probably the more sympathetic one, would allow for the continuation of SNAP benefits, but only for a few weeks. While the other claim, and it's the one that we brought, would ensure the continuation of SNAP benefits during the entirety of the budget impasse. If I can go to the next slide. Okay, the outcome was, what ended up happening is that in late October, 2 lawsuits were filed. One was filed by the attorney generals for several states in Massachusetts. I may have my courts wrong. One is Massachusetts District Court, and then the other was filed by nonprofit organizations in the Rhode Island District Court. Both lawsuits secured a temporary continuation of the benefits, but only for a few weeks. As I indicated before, we filed our lawsuit, and that was in early November, which was actually after the November 1 cutoff. And that was in the District Court, the Northern District Court of California. The problem, this was the problem with all the lawsuits, is none of these lawsuits prevented SNAP recipients from suffering a brief interruption of the benefits. The delays range from 6 days in receiving benefits to 1 month. Given the time frame, I must tell you, the 2 other cases ended up going up. One of the cases went up to an administrative stay of the U.S. Supreme Court. The Supreme Court stayed what was a ruling in one of those cases. And then it all got resolved on November 12th when Congress passed the appropriation and funded SNAP benefits through September 30th, 2026. I'm also here to tell you that we are starting to get ready for what may be the problem that looms come September of 2026. So that's it. Oh. So the lesson, what you heard before is I really think is decide whether you have the wherewithal and the ability to generate a lawsuit of this nature. And they're tough. finding clients, briefing everything, getting all set up. But you should try and be in a position where you can seek a temporary restraining order, preliminary injunction before the cuts take effect. And if you don't think so, you can do that. Then you may want to let others litigate the issue. Back to you, Joe.
Okay, for our third and final case example today, we're going to talk a little bit about a case called In Re Children's Hospital Los Angeles subpoena. So what this one was the U.S. Department of Justice issued subpoenas to approximately 20 hospitals last year, including Children's Hospital Los Angeles, that sought the private medical records of transgender youth. Allegedly, they did it to investigate the hospitals for violations of the Food, Drug, Cosmetics, and Cosmetic Act and some related offenses. We believe they did it because they were fishing. They were trying to put a chill on providers and on patients related to transgender medical care for minors. The strategy we used, we connected with community organizations in the transgender family space. This was incredibly important because not only is this where we got our plaintiffs from, but this is where we got what was needed. So we used community lawyering principles. We asked folks, how can we help? What is it that you're trying to accomplish? How can we come alongside you to get your children, to protect your children, to keep your children's medical records and information safe? So we created a case that addressed the community's concerns, which were all about the privacy matters. They wanted their children's records protected. They wanted their own identities protected. There was a lot of fear about what this information might lead to if it got into the federal government's hands. The challenge here was, of course, the Trump administration's stated goal to end gender-affirming care for minors entirely. There had been multiple executive orders to that end issued already at that point, and it was clear that, again, the federal government was using this process as part of their war against transgender families, transgender children, and transgender adults. There had been both civil and criminal threats made against providers and parents. Whether those threats were legitimate or not, still up for debate, but they were out there. And the parents of our families were seriously worried that by getting this information from the hospitals, that it might lead to criminal charges, that they may end up being criminally charged with child abuse or with other things that the federal government is calling getting appropriate and medically necessary care for their children. And then, of course, the hostility of this environment, the anti-trans community pressures against hospitals and families. These hospitals are under tremendous pressure from the community. And some of them have been absolute heroes in standing up and continuing to provide the care, and others not so much. The outcome of this case, this one did wrap up after we filed a motion to quash the subpoena. The Department of Justice withdrew the portions of the subpoena that requested the personal patient information. So they didn't quash the whole subpoena. They didn't withdraw the whole subpoena, but they agreed not to pursue sections that dealt with personal, private patient information. And then they agreed to notify plaintiffs' lawyers if they intended to reissue the demand with sufficient time for us to respond should that happen in the future. The lesson we learned here is that timing is the key. So we were delayed in filing, and the records could have easily been released before we got to court. We weren't sure even as we filed it if we were too late because the hospital refused to even confirm they'd received a subpoena, forget admitting to whether they'd responded to it or not. The part about this that was so incredibly frustrating is we kept asking the hospital before we filed, can you confirm you got a subpoena? And if so, have you already sent out this information? And they just refused to comment. They would confirm nor deny. And then within days of filing the lawsuit, and the lawsuit, by the way, was not against them. It was against the Department of Justice. But within days, they were like, oh, yeah, we got the subpoena. And no, we haven't complied. And we're like, if you had said that before, Anyway, the other lesson that we learned is that every hospital and community organization that fought these subpoenas nationwide won. So some hospitals just complied. Some hospitals didn't ever tell anyone or say anything about whether or not they had received the subpoenas. I believe we still don't know where those 20 plus subpoenas all went. But we do know that every hospital that fought them won because the federal courts were like, this is ridiculous. This is protected information. There is no reason why the feds should have their fingers in this. So it's the hope, the idea that sometimes you can win this stuff. Sometimes the federal courts are still being smart and they're still looking at the law as the law and forgetting about the policy and just saying, look, this is ridiculous. You can't do this. So that was a good outcome. All right, our last section for today is some practical advice for making this happen. And on the first slide, I'm going to turn back to Bob for developing your skills.
Yeah, I'm going to make a pitch for working on your legal skills if you want to bring these cases. These are not easy lawsuits. They involve difficult questions about standing, about the Administrative Procedure Act. There doesn't tend to be that much discovery, but there may be some. So if you haven't done these works, I wouldn't step into doing it the first instance. But it's just as, depending on where you are as lawyers, work on developing your legal skills so that you can bring a case like this. It's easy for me to say, because I've been a practicing attorney coming up next year on 50 years. And even at that, I didn't have much experience with the APA in all these years. So as you go along, start working on developing your skill set. If you don't think you have it, then co-counsel with other organizations you think that have the ability to bring the case. Or ultimately bring on pro bono counsel, who again you think has the ability. Focus on other pathways. That one is always harder for me because I tend to think primarily of litigation, and I'll make my 1-minute pitch to legal services programs in particular. I think people oftentimes think about either administrative or legislative fix, or what can I do for my individual client. And when I first started working at the Western Center many, many years ago, that wasn't the attitude. The attitude was to start out, first of all, what can we do in litigation? Is there a litigation hook that we have? And I would urge you still to think that way. And then, the answer may be in a lot of these areas there may not be, but at least think about it and think about how it is, how much time it would take, and what's involved. If the answer is you can't, or there's reasons you can, or even if you can, but there may also be other avenues, then certainly you want to think about legislative administrative policy. I'm here also to tell you, after all my years as a lawyer, I've won some major cases which I could win in the courtroom and then lost in the state legislature. So you've got to work on it overall. Learn to look beyond the individual case. Is this something that you're seeing that's just not your client? And how far is the reach? And how far is the impact? Yes, no question. You want to work with the different communities. Who are you representing? What they're doing? I worked on the subpoena case, along with Joy. I'm here to tell you, we were deeply informed by what our clients wanted to do. I'm also tell you how much they were truly terrified for the youth that their youth. And most of them were trying to protect their children from what the government was trying to do, and frankly, what the hospital might be trying to do. And then the last point is, keep in mind, when you're writing, which audience, and there may be different, how you may write for the court may be different than what you put out for the clients, what you put out for the public, the policymakers, but be in sync on that. I mean, the last thing I would simply say is that generally, if you can come up with sort of an elevator pitch for your lawsuit, that probably works pretty well with the media and can also work with policy. So that's it.
Okay, thank you, Bob. Another piece of practical advice has to do with your mindset. So you need to be strategic and not reactive. Just because you get that call on the phone from somebody who's having a horrible experience because of something that is happening out there, and we all want to jump up and save them. It's why we're in this business. We want to make a difference to the individual. We want to fix it, but we need to be more strategic because you can't fix everything, first of all, but you can't even try to fix everything because the more work you do, the less time you have to commit to each of the things you're doing. So be strategic. Think about the big issues. Think long term. What kind of cases can make a difference that will hold, a difference that will continue on into next year, into the next administration? It's all part of that idea of just, we're not in this for the moment. We're in this to make a lasting change and lasting impact. And then the last point is to treat every case as part of a larger change effort. So we did a case that involved a subpoena at one hospital, but that wasn't the big effort. The big effort here is to try and make things better and more accessible, or maintain the accessibility of care for transgender minors. So that was just one piece of it. We've got another case going on at Western Center right now against a hospital in San Diego that stopped providing treatment literally overnight to transgender minors. And so it's all part of the bigger effort to keep this this medically necessary care for the kids who need it. And then the last thing is a couple of points to remember. A hostile environment requires more strategy, not less ambition. We can still make these changes. We can still do these big things. You just need to be strategic about it. Impact litigation is strongest when it is connected to community and policy work. That is, when you are speaking on behalf of the broader community, and when you can convince the legislators that this is important work that needs to be enshrined in policy, the impact is bigger. And then the final thing for today, the question is not only can we win this case, but how does this case move the broader goal forward? Our goal is not just to fix it for this person or even just fix this issue. Our goal is to make care more accessible, make housing more accessible, make public benefits more available to folks who need them. And how does this issue, this case that you're looking at, play into that bigger, broader goal? And that's it for today. And if you all can pull out your phones and check that QR code for the survey, we must get a survey back in order for you to receive MCLE credit for those of you who are attorneys. Any questions for now, please post them. Otherwise, you feel free to reach out to either Bob or I at our emails there. We will be sharing with you after this presentation the slides as mentioned, but also the complaints and some other filings in our 3 example case studies, and an article from Democracy Forward that was published in the ABA Journal. Democracy Forward being one of our co-counsel on the Clinic v. Rubio case. And the title of that is Litigation as Resistance. A really fascinating look at how we can make the big impact, and how we can litigate in these hostile environments. Thank you all for coming today. We appreciate your attendance. We appreciate your time. And go out and get them, everybody.